Subcommittee on Justice, Public Safety, and Judiciary for the 2025 regular session. This morning, we have representatives from the Court of Justice, Finance and Administration Cabinet, the Department of Public Advocacy, all here to discuss aspects of Kentucky's guardian ad litem system, including appointment, qualifications, training, and payment. With that, I'll call the meeting to order and ask you to call the roll.
Representative Bray, Representative Decker,
Present.
Representative Kulkarni, Representative Sharp,
Present.
Representative Bowling, Representative Elliott, Representative Petrie, Chair Dietz.
Here. And we do have minutes to approve from the February 25th, 2025 meeting. So if I could have a motion. Okay, with a motion and a second, they're approved. And already seated at table, we have our first guests from the Court of Justice. If you ladies will take a minute and introduce yourself and make sure your green light is on.
Representative Dietz, I'm happy to be here. My name is Deborah Hembry-Lambert, and I'm Chief Justice. And the green light is on, but do I need to push? Okay. All right, here we go. Again, thank you for inviting us here today. Representative Dietz doesn't seem to be on now. Oh, there we go. Okay, that happened. All right, something got brighter. I think it was me. Good afternoon, and thank you for inviting us here today. My name is Deborah Hembry-Lambert. I'm Chief Justice of the Court of Justice. And to my right, I'll let this distinguished judge introduce herself.
Thank you, Justice Lambert. My name is Susan Wesley McClure. I am the Hopkins County Family Court Judge. Hopkins County is in Madisonville in western Kentucky. I also am currently serving as the president of the Kentucky Circuit Judges Association.
Good afternoon. My name is Judge Amy Sullivan Anderson. I'm a district judge in the 11th District, comprised of Greene, Taylor, Marion, and Washington counties, and I also serve as the education chair for the District Judges of Kentucky. Thank you.
And behind us, our Family Court Circuit Judge Marcus Vanover from Pulaski, Lincoln, and Rockcastle, and District Judge Eric Stovall from Muhlenberg and McLean counties. So we're excited to be here today and talk with you a little bit about what we know about the Guardian Ad Litem program and how it has evolved over the years. Of course, Guardian Ad Litems cover adoption, dependency, neglect and abuse, termination of parental rights, and some other family-related matters. And some of you may remember that in 2019, we focused on GAL fees and what appeared to be the overappointment of certain attorneys by a handful of judges. And at that time, in 2019, the gross fees charged by guardians ad litem across the state was a little over $14 million. And we recently obtained the current data, and that cost has actually gone down to around $12 million. And in response to what we found in 2019, we utilized the Family Court Rules Committee to draft a rule that prevented the overuse of one or two attorneys exclusively and require under Family Court Rule 36 for each judge to have an open list of trained and qualified attorneys. And we also focused on continuing and improving the training available to those attorneys who want to serve as guardians ad litem. And though we all went through COVID together, we have managed to have in-person regional GAL meetings or trainings throughout the state as well. We're very proud of the work that's been done with the trainings and with the rules to improve the guardian ad litem CAC system. We also worked on the attorney fee order that gets submitted to finance so as to collect better data related to the case type and role of the attorney seeking payment. And so far as how much attorneys get paid when they serve as a GAL per case, the maximum fee that they can charge per case at the trial court level was set in 1986 at $500. This morning, I checked ChatGPT to ask what today's $500 would have been worth in 1986. And I was actually shocked to find that adjusted for inflation, that's only $172.56 in today's dollars. And $500 in 1986 was actually worth $1,449.23, according to ChatGPT. So in the future, and today's not the day, but in the future, we do need to talk about the fees of guardian ad litems and to make sure that we are providing sufficiently to cover the constitutional needs of representation of persons in these case situations. But again, that's for another day. I brought with me today these 4 distinguished judges who are, as a part of their daily chores, handling these family court dockets and appointing attorneys and signing the fee orders. So with that, Judge McClure.
Thank you. Thank you, Justice Lambert. I want to thank the committee members for inviting. Okay, thank you. Can you hear me now? Okay. I want to thank the committee members for being here today to discuss what all of us would agree would be a partnership to protect our most vulnerable citizens, the children in the state of Kentucky. This is an ongoing process by not only the judicial branch, but the legislative branch and the executive branch to ensure that there's competent and quality representation for these children and their parents. Their parents face a deprivation of fundamental parental rights in many of these cases. That is not something to be taken lightly, and I know that you don't. Quality representation, studies will show that quality representation directly impacts what outcomes we have for children, whether those outcomes will be for future years positive for them or whether they will not be. So we are committed as the judicial branch to ongoing attention to these issues, and we ask that you join us in partnering with that initiative to ensure quality representation. We believe overall that our current system is working well. Our system is administered basically on a local basis, ensuring that those attorneys who are appointed are familiar with the resources that are available in their jurisdictions, and even more importantly, that they're familiar with the community culture. We acknowledge that there have been previous concerns from the legislature and from the Court of Justice, but we believe that we have taken those concerns seriously and have responded in effective ways. As Justice Lambert mentioned, we have looked at updating rules and have done so. We have had non-exclusive appointment lists become the requirement, not just the norm. We have enhanced training for attorneys that have been involved in these representations, and we have imposed more judicial oversight. We realize that as the legislature, you are tasked with budgeting for the state, and part of that is a concern, reflects your concern with some of the fees that have been charged in these cases. In looking at what that information has provided through the Cabinet for Finance, we have looked at the number of fees that have been charged in this past fiscal year and the number of cases. Overall, it is an average of $650 per case, which I'm sure you recognize is just a slight amount over the fee cap for one attorney. The fees that are collected are gross, not net. And those of you who are attorneys recognize that out of your gross fee, there are many expenses. Several of our current attorneys serving on this panel are serving multiple counties. They don't get reimbursed for mileage. They don't get reimbursed for administrative assistance. They are not reimbursed for printing costs or telephone bills or any of those normal expenses that come through a private practice. As Justice Lambert previously said, when this task began back in 2019, we were looking at an overall fee of a little over $14 million. Now we're looking at fees that totaled approximately $12 million. That is in spite of the fact that these dockets have been continually growing. You'll not speak to many judges, if any, in the Commonwealth that handle these types of cases that won't say, my DNA docket is exploding. In 2023, we had a little over 18,515 cases in Kentucky. In 2024, we're up another 500 plus cases. So while the number of cases is increasing and while inflation is increasing, these fees have been reduced. In Kentucky right now, if you look at the current fees that the Cabinet for Finance can provide, there are only 22 attorneys in the state who have grossed from those fees over $70,000. Over $70,000. Most of those attorneys are serving in multiple counties. Another thing that the Judiciary has noted for several years is that our Cabinet for Health and Family Services and our Cabinet for Finance is not taking advantage of a possible reimbursement from federal 4E funds. The Court of Justice, we can't enter into the agreements. We cannot seek those funds. But those cabinets can do that, and they can do it merely by entering into a memorandum of understanding and working with that 4E office. So we would encourage the legislature to look at that possibility and to look at encouraging those two offices to seek that reimbursement. There are some difficulties that particular rural counties have in finding enough attorneys to cover these types of cases. As many of you may be aware, the Kentucky Bar Association has recognized that our attorneys in rural areas are declining. These are complex, emotional cases. They have a high burnout rate. The fees are woefully low when you consider that these are the people who are representing parents who are basically facing a death penalty for their family. In my jurisdiction, the current fee, which is lower than many parts of the state's billable hour, my current attorneys on my panel, the $500 fee represents less than 3 hours of work. And that's looking at an ongoing billable rate of approximately $175. Our panel has prepared today and assembled some information for you, and we're happy to answer any questions that you may have. If we don't have the answers with us today, we're happy to dig those out and provide them to you at a later date. But we want to continue to partner with the General Assembly to ensure that the rights of children and parents are protected. We would appreciate participating in a joint task force if you think that that is appropriate, and we would appreciate any questions that you may have.
Again, I'm Judge Amy Sullivan Anderson from Greene, Taylor, Marion, and Washington counties in the central portion of the state. I'm here today to highlight the availability of attorneys in our rural districts. You may wonder why you're hearing from a district judge. Our circuit has 2 district judges and 2 circuit judges. We, along with 22 jurisdictions, have no family court judge. So therefore, the GAL and court-appointed counsel duties are shared by both our circuit and district judges in those areas. As far as the criminal or DPA availability in our areas, our Columbia DPA office is just south of our district. And I would like to point out that it's only been fully staffed briefly 2 times in the 18 years I've been on the bench. At this time, our district court criminal dockets are covered by the Department of Public Advocacy as follows. In Greene, we have a retired DPA who is under contract. In Taylor County, we have a contract attorney traveling from Representative Decker's county of Shelby County to Taylor County to cover those dockets. In Marion and Washington, we just recently lost another staff person from our Columbia DPA office, and we are now being serviced by DPA staff traveling from Jessamine County an hour away to cover our criminal dockets in Washington and Marion County. Our 11th district, for the first time in the 25 years I've been an attorney, has no DPA attorney assigned to the Columbia office covering our district court dockets. We are part of the rural attorney crisis that Judge McClure mentioned. It is highlighted by the KPA on their website, and if you've not read their report, about rural justice and the attorney crisis. I hope that you will take time to do that. It is quite sobering. In Greene County, I have 8 practicing attorneys. You may look at that report and see the number of attorneys that are listed, but it doesn't take into account those that aren't practicing or those that are practicing in maybe the private sector or are appointed for other things such as trial commissioners. In Greene County, I have 8 practicing attorneys. When you remove the county attorneys, staff, and other attorneys that do not practice in these areas, I only have 2 attorneys to appoint in Greene. Most cases require 3. In Taylor County, I have 21 practicing attorneys. 11 of those are in prosecutors' offices. Unlike urban areas, our Commonwealth attorney is full-time, but none of her assistants are full-time. The county attorneys are all part-time in our areas, and so therefore you have those attorneys able to engage in private practice, which offsets what they may make as an assistant county attorney or an assistant. Those assistant prosecutors, like DPA staff attorneys, qualify for loan reimbursement. However, again, the ability to have a private practice allows them to have quite a lucrative practice. Also, the pay with the prosecutors has increased in recent years with restructuring, and actually our Commonwealth's attorney is paid more than district judges are at this time. Also, removing the incentive for well-qualified attorneys to seek judicial positions in our rural areas. Our circuit judges rank 48th out of 52 states and territories in spite of the recent pay increases, for which we are very grateful. District judges are paid less than that and do not have a nationwide benchmark to rank our pay. But to get back to our available counsel, out of those 21 attorneys in Taylor, I have 4 attorneys to appoint. One of them wants out due to the mental stress of the job. One is retiring in the next year, and the remaining 2 practice in the same office. So therefore, I'll have 1 out of 21 within the next year. In Marion County, 23 attorneys dwindles down to 5 attorneys to appoint. In Washington County, we have 8 attorneys, 6 again in the county attorney's office, 1 trial commissioner, leaving 2 attorneys to appoint, again for cases that take at least 3, if not more, attorneys. We are lucky to have attorneys who have agreed to travel to those counties, but that increases their time and expenses and effectively reduces their net compensation. I have 1 attorney from a county 2 counties away who appears by Zoom, but these really are not the type of cases that have effective representation from a remote attorney. A further complication is if cases are filed by private counsel instead of the Cabinet for Health and Family Services, and that further reduces the number of attorneys available to serve. So why do we have so few attorneys available? New attorneys are no longer expected to pay their dues and serve these type of courts to earn their badge, so to speak, to earn their stripes and to begin their practice. Attorneys are staying in urban jurisdictions because there are more opportunities for specialization, better pay, more attractive quality of life with opportunities for social activities in their families. Pay is another issue. The circuit court counselor are paid $500, as we've highlighted, while district court counsel by statute are $250 for the exact same work. In recent years, the district judges have succeeded in entering equal protection orders, and the Revenue Cabinet is now paying our attorneys $500 in spite of the fact that the statute says $200. These fees have been the same since the implementation of the Juvenile Code in 1986. Our attorneys travel, have expenses, and do not just appear once for the clients. A minimum number of appearances would be 4, and that's if you're very lucky. But in reality, these cases go on for more than 1 year, all for 1 fee. Last year, one of my most frequently appointed attorneys, a solo practitioner, received $8,000 for her work. She takes cases in 2 of my counties. She bills $150 an hour for private pay. If she had that for just the number of hours she was in our courtrooms during the week, she would be paid more like $24,000. As you can see, she's grossly underpaid for the work she does on our cases, but fortunately we have attorneys who see this as a noble service to the courts and the public and essentially work pro bono. All of this information shows that DPA is not staffed to cover providing up to 3 attorneys per case. Our appointed private counsel is doing the work for much less than a salaried DPA with benefits, and they also deserve to be paid more, which will still be more cost-effective than appointing DPA. Further, we need to improve the pay to attract more attorneys to do this very important work. Thank you.
Court Judge Marcus Vanover from Pulaski, Lincoln, and Rockcastle, and we also have District Judge Eric Stovall from the Plain Counties.
Chairwoman Deets, members of the committee, I too want to thank you for the opportunity to be here and to speak about GAA. There we go, right? Okay. All right. I was tasked specifically to talk about a particular portion of this, and that is the conflict situation. Were we to move from a model of local representation by local members of the bar to perhaps one that was staffed on a DPA model or by DPA itself? The local attorneys that I have practicing in my court, they set that time out of their schedule. They are there. I know they're going to be there. It's a reliable model of representation that I know I'm going to have those attorneys on certain days for those dockets. DPA, by its very nature, the way their offices are set up, and this is where a little bit about my background may help you. Prior to taking the bench 2 years ago, I was with DPA for approximately 15 years. 10 of those years were in management, where I managed an individual office, but I also covered a region. So as you can imagine, in that time, handling 6 different offices, there were a myriad of conflicts that had to be dealt with on a weekly, if not daily basis, relating to covering just criminal cases for those offices. So it's within that context, if DPA is being considered as a model for representation in these cases, that we have to take into account. An individual trial office may be covering multiple different jurisdictions out of that individual trial office. They may be covering McLean District Court, but for example, the same office would be covering Hopkins Family Court. That's all out of a single DPA office in Madisonville. It's with that structure in place that we also lay it on top of that, something which I know those of you on the committee who are practicing lawyers, any given courthouse in any given day has 3 or 4 judges running simultaneous dockets within them. If there are multiple district court judges, sometimes those dockets conflict. Sometimes the district court judge's docket conflicts with the circuit court or the family court. And it's within that framework to put in a DPA office, and I suspect you'll hear some of this from the DPA representatives later, so I won't unnecessarily belabor the point. Those offices are not structured in a manner that would allow them to cover those cases, as opposed to what we have now, where we have a dedicated list of people that's administered locally who have set that time aside and have the practice experience in those areas. On top of that level of conflicts, which is just a practical matter of scheduling and logistics, we also have the very real hard conflicts that would exist within those cases. And by that I mean, by the very nature of these appointments in these cases, they often accompany criminal charges that would go along with them as well. Conceivably, we could have a DPA office that were to be tasked with perhaps representing the child in the JDNA case, while simultaneously they've received an appointment either from the district court or the circuit court for representation of mom and dad in a criminal case that has come about as a result of the JDNA petition. So it's really those 2 areas that we have there working together, where if the representation and appointment of counsel were to be moved from a local model to one more of either a regional or a Frankfurt model, there would be, I don't want to use the word nightmare, but I think that probably does not undersell the conflict situation for which we would be walking into, and that's there. DPA is a very good agency. I was proud to work for it for the 17 years that I was there. They provide excellent representation to clients charged in criminal cases, from something as simple as a harassing communication all the way up to a capital murder case. The flip side of that is we have an excellent representation model, I believe, already in place for the JDNA cases. Now, are there shortcomings and things that we need to address? Absolutely. And I welcome this forum and this meeting here as perhaps a first step upon finding solutions to those problems that do exist. But from somebody who was in the trenches for 15 years, handling cases and staffing out cases, I can say without equivocation to this committee that there would be what is, in my opinion, staffing problems and conflict problems and scheduling issues that I do not think could be overcome. I thank you for your time and attention.
Thank you, Chair Dietz, for allowing us to present today. Again, my name is Marcus Vanover. I'm a family court judge in the 28th Judicial Circuit. One of the what I'm going to talk about primarily is the training. As we've focused on, in 2019, there was an audit done of the guardian ad litem appointment process, and in one of the shortcomings that was noted there was training for the court-appointed counsel and the guardians ad litem. For approximately 30 years, there had always been a requirement that our court-appointed counsel and guardians ad litem, to be eligible for appointment, had to have a basic level of training. And that had been in place for many years, but there was no assessment on what detailed the training had to be, how long it had to be, and whether there's any continuing training obligations. As a result, we were in the process of revising the statewide family court rules, and one of the things that was incorporated into that rule change was a training requirement as part of that. So in revising the rules and coming up with appropriate standards for our court-appointed counsel, we looked at multiple sources to come up with suggestions for these trainings. One of the things that was used was the Child Welfare Law Specialist Certification Standards of the National Association of Counsel for Children. We additionally looked at the ABA Center on Children and the Law, Legal Representation in Child Welfare Proceedings, which includes responsibilities for the judges in oversight and hallmarks for parent and child attorneys that are taking these type of cases. Another thing that was looked at is the Family Justice Initiative, attributes of high-quality legal representation for children and parents in child welfare proceedings. From all of these sources, we came up with new standards for that our court-appointed counsel and attorneys had to bear and had to be responsible for, and we came up with some suggestions for the training on that. The current rule, Family Court Rule of Practice and Procedure 37, still requires the attorneys to undergo the initial training. Additionally, the new rule requires 4 hours of multidisciplinary training for each attorney to remain on those lists every 2 years. We specifically want them to focus in areas not only of the law, but also child development, trauma-informed care, dealing with individuals with substance abuse disorders, and child welfare and forensics. The initial training was revised in 2020. The first rollout of that training was set, I believe, in about April of 2020, and as we all know, in March of 2020, lots of things kind of came to a halt. But the courts of justice were still able to offer those trainings and quickly convert those into remote training so that we can start imposing those standards upon our court-appointed attorneys from the beginning. The initial training focused on reasonable effort standards under both federal law and the state law. We talked about procedural law, how to handle the dependency, neglect, and abuse cases from beginning to end. Additionally, we looked at termination of parental rights cases and made sure that our attorneys were proficient in handling those from procedure from beginning to end. There were classes on early childhood growth and development, later childhood development, evidence, trauma, and finally how to handle appeals of these type of cases. Recently, we have shifted into making sure that the ongoing training is been enhanced also for the attorneys that are going to remain on the list. In the fall, we undertook regional trainings across the state. Some of the new training focuses are understanding and communicating with clients. During one of the Kentucky Judicial Commission mental health roundtables that they held last year, one of the attorneys came forward and was talking about the challenges that are dealing with the increase in mental health for our parents and increase in mental health issues for our children, being able to effectively communicate and knowing how to deal with the crises that our families are facing. And so we undertook an effort to make sure that that is incorporated into our training for these attorneys so they'll know how to deal with those things. We focused on practice concepts, parenting, being taught by parenting coaches, psychologists, and attorneys to make sure that we're having a wide range of expert knowledge into our training so that these attorneys are equipped in the best way to handle and represent our panels. We have lived expert panels. We want to have our attorneys get a feel from individuals who have been through the system and been through this process and kind of know from the firsthand experience what they are experiencing and how that impacts their families and lives so they can gain that perspective. And additionally, we focus on ethics and training for the court-appointed counsel. One thing that I did want to clarify, and I know you've heard it from a couple of our sources already, the analysis of the fees. If you take the number of cases that we have and divide it amongst the total number of fees that have been paid out by the Finance Administration Cabinet, it come out to about $650 per case. Again, I want to reiterate, that's per case, not per attorney. Often these cases have at least two, sometimes even three. I've had cases that have at least 5 attorneys appointed. So while the fee is capped at $500, we're not, I don't think we're really getting close to that with most of our cases that we're handling. And that's all I have. Thank you.
I want to thank the Chief for inviting you all here to speak today. And as a little bit of background, and I maybe should have started with this, I think the Chief and I have had 2 conversations. The first one, I'm new to this role. She was just coming in as Chief, and the AOC Director was also there, who was just on the job a few days. And I think we identified this as a priority for all of us. This is a discussion. We're not voting on anything today. I know over the weekend, it's amazing when an agenda goes out, how many texts you get, what's her qualifications, who is she, I'm going to be there to testify against the bill. So I heard all sorts of things. We're here to gather information. And in fact, some of the information I gathered very transparently gave it right to the Chief's office immediately. That included this, which I've gone through, which is the payments for the guardian ad litems in their cases, which I'm happy to share with all the committee members, and showing how much they've been paid through the fiscal year and then up until I think January when I requested it. I also spent a lot of time reading the report from 2019. And as background for those that may not know, I'm a practicing lawyer for 31 years in the area of family law. I sat on the board for legal aid of the Bluegrass for 10 years and worked at the Children's Law Center when I was a law clerk. So I feel that I have some qualifications and also was a guardian ad litem in DNA court as a newer lawyer and continue to take those appointments when asked on adoptions and have a very active practice in addition to this job. So this is something I feel very strongly about, and I think actually the study from Kenton County came from some inquiries that I asked about a decade ago. And I think the problem there was that we had a judge that was adding trailers on to the cases and increasing fees. And so I just wanted to put that out there. We're here today to gather information so that no decisions have been made. There's no bill to vote on. We're here to get information on fees, on how the program could be better run or efficient, centralized. So I'm just exploring all sorts of options as we go into the budget year. So I probably should have said that at the beginning. This was not meant for anybody to come in and try to testify against ideas or thoughts that we have. It's an ongoing discussion, and I know it was identified as a priority for me and for the chief when we came in. So with that being said, I really appreciate all of the information. And my one question, I know the comment's been made that on average this is $650 per case. My concern is when I took the information that I have and had my intern break this down for me by attorneys that made more than $50,000. We have an attorney out of Jefferson County that made almost $150,000. So concerns on, and I haven't been able to go through all this, is it a county issue? Is it a judge issue? Is there an abuse somewhere that's going on? But I certainly, to your point about the rural areas, they may not be paid enough, but we may have other people that are abusing the system. To say on average it's $650, I want to make sure the attorney representing the child or the parent is getting paid what they should be getting paid, and not that this all comes out in the wash at some point. Because I do know that, I mean, we have attorneys that are in the legislature that serve in this position, and I know what types of cases they take. I also know what happens in the northern Kentucky counties. So that's a concern, and why I took it seriously enough to start breaking this down, that we have attorneys that are making almost what judges make. So I just want to know what's happening there and why is that happening, and is there a better way for us to track? And perhaps we don't have the right pieces in place to get the right data. So as I'm learning my job, data is really important. So are we getting this from termination cases? Are we getting this from DNA cases? And that's not reflected in the report that we have. They did, I think in this report, one of the recommendations in 2019 was to break it down between the attorney for the parents and then the GAL. And they were able to do that. So those are just more questions, right? We get a report and then we have more questions. So I wanted to lead with that. And I don't know if any of the other members have specific questions on the role of a GAL or payment. And any comments after I've made that?
So I did see the report in the figure that you're talking about, and I don't know the ins and outs of it, but one thing I would point out for that year and that fee, the majority of that fee seemed to have come from appointments in domestic violence and interpersonal protection under that, not in the dependency, neglect, and abuse appointment cases. And at that time, I'm not sure, we were kind of going through is before the statute came into have finance and administration pay for those, and I think there was a little less guidance on that. I don't know why those fees are what they are, but I did note that those were before the statute that capped the fees at $500 in those, and the biggest portion of those fees did come out of the domestic violence and interpersonal protective orders.
Thank you. Any members with questions on that? Representative Decker?
No, I don't have a question. I just wanted to thank you all. I've spoken with Representative Dietz about this very briefly. You all helped bring the problem more clearly to me. Didn't get to talk long, so I appreciate that you came. We can't know all of this if we're not there. So thank you very much.
All right, thank you. Next on the agenda is Finance and Administration Cabinet. So if their representatives want to make their way to the table. If you all each would want to introduce yourself, please make sure your green light's on.
I'm sorry. That's us. Perfect. Thank you. Oh, okay. Fancy. Good afternoon, Chairman Deeds and members of the committee. Thank you for this opportunity for us to speak with you today about the Guardian Ad Litem program and the advancements that we have made for the payment processing and the operation efficiency under the Office of Budget and Fiscal Management, which is housed under the Office of Administrative Services. And you know what? I just realized you don't know who I am. Okay, so I'll start with that. My name is Tina Howard. I am the Executive Director of Office and Administrative Services, and we are housed in the Finance and Administration Cabinet.
My name is Cindy Hall. I am a staff assistant at the Office of Administrative Services.
Good afternoon. I'm Sean Dutta from the Office of Legal Services for Finance and Technology.
Okay, sorry about that.
That's
the report you have that's several hundred pages long, and it's due to the report come on with the finance cabinet. We used to just get them all through. Time through electronic.
I don't think your mic's on.
Okay. Okay. Can you hear me now? Okay. We now have 4 full-time employees. So I do want the Finance and Administration Cabinet under my leadership. We, in the Office of Budget and Fiscal Management, we did, with the Secretary helping in this direction, we now designate 4 people, 4 employees full-time to work the payments. The personnel cost, however, was totally absorbed in our current appropriation in the Finance and Administration Cabinet. Improved staffing and training have eliminated payment backlogs. Duplicate payments requests can now be accurately identified. Daily management review of EMARS reports, strengthening the financial oversight. These measures reinforce accountability. Through these advancements, the GAL program is now operating more efficiently and effectively, ensuring resources are used wisely while continuing to support Kentucky's most vulnerable citizens. Please take a moment to look at this slide. This slide.
Before you go any further, could
Okay.
you describe for the committee what it is that you received a process to pay the attorney?
Okay, we have that in the presentation.
Okay.
Is
Go
that
ahead.
okay?
That's fine.
Okay, thank you. This slide right here, and what we're doing is we're trying to give you the information on where we got to today. But each fiscal year, it's broken down, total annual expenditures. So what that means is that's how much the appropriation that was appropriated, that is what we used of that. They do put in the budget bill where we can use the budget reserve trust fund if needed, if not enough is appropriated. So that language is still there. And we thank you very much for that flexibility with this program. Total annual documents processed. When you look at that, we have document that we call the FinGal 1 that you have to submit that as an attorney, and it has to be signed by the court. That's how many we process each year. So currently we're at 16,400, and we're almost at $8 million is how much we have processed. A little at the beginning of February when we knew we would be coming today and speaking. So currently in fiscal year 25, the General Assembly has appropriated $12.3 million in fiscal year 25. And we do want to thank the General Assembly because this program, their support, your all support, has greatly helped make this program better than it was 5 years ago. So we totally appreciate that. So I'm going to turn it over to Cindy Hall. She's going to explain more of what we do on a weekly basis and the payment process.
Okay, good afternoon. Each week, we receive approximately 881 forms to be processed. To be fiscally responsible, the case number and reporting mechanisms are used to identify duplicate payments. This is important as we receive approximately 260 duplicate payments each week. One of the forms that we received, approximately 66 forms are submitted that must be returned for corrections, and our staff processes approximately 525 forms each week. The GAL staff strives to process payment requests as quickly as possible using KRS 45.453 as a reference for timely payments. Attorneys must complete the FinGal 1 form to request payment for cases that they have been appointed to. The FinGal 1 form is a 2-page document that can be found on the Finance and Administration's website. All fields must be completed, and the form must be signed and dated by the attorney, by the judge, and must have an entered stamp from the court present. Once the FinGal form is completed, it can be submitted to our office by email, or by fax. Email is most used, and that is the most efficient way to submit the form. The form undergoes a pre-audit to ensure all fields, signatures, and stamps are provided. At that time, they also do the review of the case number and the reporting mechanisms to ensure that it's not a duplicate payment. Any form not meeting the pre-audit requirements will be returned to the attorney for corrections. Once the pre-audit is complete, the payment information is entered into EMARS, the statewide accounting system, to create the payment document. The payment document is reviewed for final approval, and once final approval is applied, then the payment is submitted. It will initiate the payment to be dispersed to the attorney. Payments being dispersed can be by check or electronic funds. Of course, electronic funds is the best option because it's the fastest way for the attorney to receive their payments.
So that's the payment process. And we really thank you for letting us come, because this program, and I think the administrative side sometimes gets hidden in what really does drive to get the payment to the attorneys and serve them. And it is it's a program that has a lot of volume to it.
One of the recommendations in the report, or an issue that they spotted, was partial payments. Is that something that has been addressed with you all in receiving partial payments where maybe they submit that twice?
No, there's not been anything addressed to us. We are aware that there are requests for partial payments. We do make sure that the partial payment doesn't, if we have to do a partial payment, that the combination of them do not exceed the $500.
And to the best of your knowledge, is there a deadline for them to, for the GAL to send their form in upon completion of the case, in the middle of the case?
No, ma'am, there's not.
Okay, thank you. Any questions by the members? Thank you very much.
Okay, thank you.
And then last on the agenda, we've got the Department of Public Advocacy. Good afternoon. If you all will introduce yourself and make sure the green light's on.
Good afternoon, Madam Chairman and other members of the committee. Thank you for an opportunity to be here. My name is Damon Preston. I'm the public advocate for the Commonwealth.
And I'm Brad Holleiter. I'm the Conflict and Contract Division Director for DPA.
Hello, I'm Melanie Foote. I am the Division Director for Education, Recruitment, and Strategic Planning for the DPA.
Madam Chair and members, we're the one organization that does not have a PowerPoint today, and I hope it's okay with you. Our approach to this whole conversation is we want to be a resource and be helpful where we can be helpful and step aside when we need to step aside. We are organized and created by statute to fulfill the state's constitutional duty to provide indigent defense services in criminal cases. That is not a natural extension from that to GAL work. But we are proud of the organization we have, and to the extent we can be helpful, we want to be helpful. I've put together a document that I submitted to staff and only sent it this morning, so it may not have been distributed, but I want to quickly just go through some high-level thoughts that we have on this process. Number one, a reason that DPA could be involved in this conversation is we do have a statewide network that's pretty well respected with a national reputation for excellence. And we have a client-centered approach to providing legal services. And I think the GAL space is a place where that type of organization could be helpful. And so, again, we're willing to be helpful if we could be. And we have an existing conflicts and contract services division that Brad heads that if DPA were going to play a role, that would likely be how it would be accomplished, would be through a separate division. I don't disagree with anything that the judges said about the current state of DPA, both ethically and the conflict situation, and also the staffing challenges that we have. Both Judge Anderson and Judge Stovall approached me in the hallway to kind of apologize in advance for saying things about DPA, but it was completely unnecessary because I agree with everything they said. We're aware of the possible conflict situation, and we're very aware of our staffing problems and the problems of getting attorneys to go to rural areas of Kentucky. And that's something that in other settings perhaps we'll talk to the chair about in advance of the budget presentation next year. But my thought on how this could possibly work would not in any way be that the GAL cases in Adair County would simply be assigned to our existing Columbia DPA trial office. I think if that were the model, and when this conversation started, I think over a decade ago, there were some who thought that's the way it could be done, is simply give DPA one or two more attorneys in their trial offices and let them do this. That can't work institutionally, and it just wouldn't be the best approach, because in a lot of rural areas, the best approach is a per case private attorney, either contract or voucher system, similar to what exists now. That's the best model, and there's no reason for us to swoop in with full-time state employees to take over that work. DPA could play an administrative role in organizing and holding that system accountable. We have, again, a statewide model for already doing that through conflict cases and through our own work, so we could play a role there. Possible negatives, in addition to the conflicts, would be if it's given to DPA and it's not adequately funded, or frankly, if it's not adequately managed by us or our successors down the road. Essentially, you've got two critical systems that are starving at that point. You've got a public defender system and the GAL system that rise or fall together, and there's a risk to that. I have great confidence if it comes under current leadership that we would provide the expertise and the resources as much as given to us, that we would provide, we would dedicate the time and attention to get this done right. But you are linking them for the future if it comes to DPA, and there's a risk to that. If DPA were going to be involved, we absolutely have to get the resources that are necessary, and that's not just the $12 million that's being written out. That's money for training, that's money for administration, for leadership, for programmatic expenses. We would need a case management system. I was very interested in the finance presentation just now, talking about that they've graduated from snail mail to email, which is certainly an advancement, but there are products available in the defender space that would provide vouchers, a portal that would be helpful here and be a much more efficient system than even an email system could be. So that would be an advantage of some type of statewide oversight by an organization that was invested in the system, not just writing checks based on vouchers. Another thing that would be necessary in addition to resources the statute would have to be carefully written, and that's why I fully support the chair's statement that this is a conversation that will go on for a long time, and the end product needs to be a clear statutory definition of what DPA's role would be, and how we would be have an interplay with the judicial branch. A challenge that DPA uniquely has is that we work in the executive branch, but we work in the judicial branch, and judges can control our actions, but we don't technically work for the judges. We work for the governor. And so we've worked it out in our public defender world, and we would need to similarly work it out if we play a role here, if an executive branch is going to be filling this critical role within the judicial branch. Open questions would be what level of reform or change do we want? Are we simply looking for a new way to administer the current system and just kind of change oversight? Or do we want a full-fledged reform of the system with DPA bringing values to it and providing services to improve the representation that's given by GALs? That would be, and there are grades in between those two extremes, and we would need to figure out how far we want to go. And also, what types of GALs are we talking about? Are we talking about all 10 of those that finance just put up? And I noticed that 202C cases, which are criminal cases where the defendant has been found mentally incompetent to stand trial, that wasn't on their list, but I believe that statute also calls for a GAL. So there are several settings in which this is used. Are we looking for a solution for all of them or just DNA cases or similar? I will stop at that point. But we are mostly here to be a resource and to answer questions, and we're willing to take any questions that anyone has.
Now, I want to thank you for your time, and we've had some good conversations, again, exploring what that could look like, addressing concerns that were in the report from 2019, and I don't have any questions for you today. I think we're having just an ongoing conversation and listening to what your concerns are. So I don't know if any of the members have any questions. And if not, thank you for being here today. And then this meeting's adjourned.
Thank you.